a little bit about guardianship and alternatives to guardianship. Just as a brief introduction, as Jenna said, I am a special needs attorney at State Pitney Law Firm. I have a son. You'll see a picture of him. Well, I have 4 kids. My oldest son, Connor, has what's called Williams syndrome. And so that's how I got into special needs planning. I was an attorney before he was born, but once he was born, I started learning everything I needed to know about being a parent to him, and finally figured out that this is sort of my calling and I should stop doing civil litigation and go over and do special needs law. So I've been doing that for about 15 years now. So I do guardianships, I do special needs trusts, all of that. But tonight we're going to talk about guardianships and the alternatives. So I'm going to hopefully successfully share my screen and get started. All right. Hopefully this works. Okay. All right. So let me make sure this clicks through. This is not clicking through. Oh, there we go. So here's a picture of my son Connor. So this is why I do what I do, and this is what puts me in the same boat as all of you guys. So that's my cutie pie. So again, tonight we're going to talk about guardianship and all of that, what that entails. So what the powers and duties you have if you do become guardian of your child once they're an adult, what the procedure is as to how to get that done, and something called substituted judgment, which is sort of an elevated higher level version of guardianship that I'll talk about. We're also going to talk about supported decision making and alternatives. This is something that is starting to gain a lot of steam. It is something that a lot of parents are now at least thinking about. It's something that I think 5-10 years ago, people didn't know that there was an alternative to guardianship, and maybe you don't know that there's an alternative to guardianship. So I'm going to talk about that as well, so that you have all the information you need in order to make the best decision for your child and your family. So the basic concepts, legal emancipation. What that means is that when your child turns 18, just like everybody else who turns 18 in Massachusetts, you are legally emancipated. You are an adult. You get to make your own decisions. You can enter into legal contracts, and you are emancipated. You're an adult. There is a presumption of competence, which means unless a judge affirms that someone is incapacitated and unable to make their own decisions, there is a presumption that someone is competent. That means for all of our kids with special needs, when they turn 18, they are presumed to be competent to make their own decisions. The only way to get over that hurdle and to decide that they are incompetent is really through that guardianship process and a court order. Least restrictive alternative, we're all used to hearing this, right? It applies to basically everything about our kids' lives. So we hear it a lot with school. We want the least restrictive placement, the least restrictive educational strategies. Well, it's the same thing with guardianship. So the judge is looking for the least restrictive alternative to guardianship. So you may need guardianship of your child, but do you need to make every decision for your child? Are there any decisions that your child maybe is competent to make? Maybe your child is competent to make decisions relative to his own activities of daily living, ADLs. Can they make their own decision as to what clothes to wear, who to be friends with, what type of religious activity, to be left alone, to drive, to vote? Are there some areas where your child can make those decisions on their own, even if it means with help, with assistance? Or is it that you need what we call plenary guardianship, which means your child is not competent to make any decisions and you need full guardianship? A judge is going to want to see that. So we want to prioritize, as I said. There are some areas where maybe your child can make their own decisions. So there's a range of legal options, and not all of them are options through the court. So I just want to highlight a little bit of what they are so you understand some of the different roles. So on the left here, this is court-appointed roles. So guardianship, as I said, this is you are petitioning the court to be guardian of your child, or maybe some other family member is doing it, but I always sort of fall back on the parent-child relationship. So I understand that some of you, it may not be that. Maybe it's a grandparent, it may be an aunt or uncle. Sometimes I have a lot of clients where they're older and it's a sibling who is getting guardianship of their brother or sister. But again, for tonight's purposes, I tend to fall back on the parent-child relationship, but it applies to everybody. So guardianship, the basis for that could be your child has an intellectual disability. It could be that there are mental health concerns involved, or it could be similar to a child. It could be a parent that has dementia. Maybe your mother has Alzheimer's, and if she doesn't have the right incapacitation documents, legal documents in place, you may need to be getting guardianship of your mother. Another court-appointed role is conservator. So a guardian is guardian of the person. That means you're making everyday decisions for someone. Where are they going to live? What is their IEP going to look like? What type of services? What type of medical intervention? It is not any power over finances. That is this role, conservatorship. Conservatorship, some people say conservatorship, really you can say either. But a conservator is someone who is appointed to deal with somebody else's finances because they're unable to. The reality is, in my situation, 99.9% of my clients never need to get conservatorship of their child because A, their child doesn't really have any money right now, and B, if your child is on government benefits, there's a $2,000 asset limit, so they're likely not going to have a lot of assets. So there's really no need for a conservator. This comes in when someone is getting guardianship later in life. Maybe someone was in a car accident and is now disabled, and you need to get guardianship and conservatorship. Or again, your elder parent who is in the nursing home, maybe you need to get conservatorship of them. But for our purposes, typically conservatorship doesn't come into play. A Rogers guardian, that's what I just said, a substituted judgment. I'm going to talk about that. It's just an additional layer to the guardian for some higher level decision making. But it's important to know that there are a lot of roles that you and or other people are going to play in your child's life that has nothing to do with the court. There is no judge involved, there's no court involved, but somebody has authority to make decisions for your child in these instances. So the first one is trustee. So if you have a child with special needs and they're going to be on government benefits, they're maybe financially naive, and they're going to be subject to exploitation, you want any assets that your child is going to receive, usually upon your death or maybe upon a grandparent's death, any inheritance, you want that to go into a special needs trust. I'm not going to talk about that trust tonight, but what you should know is the trustee who is named in that trust document. So I'll just fall back on my own situation as hypotheticals. I have the Connor Green Supplemental Needs Trust. And right now I'm the trustee, my husband and I, but I've named my siblings or a friend or a professional to be successor trustees so that when my husband and I die, any inheritance that Connor's going to receive is going into this special needs trust for him with my sister or a professional as the trustee. That trustee has full unfettered access to all the money in the trust. The guardian does not. The guardian, it could be the same exact person, but the guardian has no access to the trust. The trustee does. As I said, it can be the same person, but they're wearing two different hats. So it's important. People tend to get confused. They think the guardian is going to be in charge of the money, but it's totally separate roles. These other three, these next three, these are what I'm going to talk about a little later on. These are alternatives to guardianship. Maybe your child has capacity and your child can sign a power of attorney, a healthcare proxy, an appointment of advocate saying, okay, I understand that I need help making decisions, and I'm going to sign these legal documents saying this is who I want to help me. I want mom and dad to help me. And if my mom and dad can't, maybe I want Auntie Kate or Uncle Drew to do that. So those are documents that your child who has capacity, again, they're not under guardianship, because once they're under guardianship, they are now presumed incapacitated. But an alternative to guardianship, someone can sign these documents. Again, I'm going to review all of these at the end, but I just want you to understand these are not through the court. This is not a court appointment. These are through legal documents that you would set up with or for your child. This last one, representative payee, this is someone who is appointed by the Social Security Administration to be in charge of your child's SSI money or SSDI money. Again, applying for that source of income and which one your child is getting is a subject for another day. But just so you know, when your child is turning 18, most of my clients do apply for SSI, Supplemental Security Income, for their disabled child through the Social Security Administration. And the Social Security Administration is going to look to appoint someone as the representative payee in charge of those funds. If your child is under guardianship, they're definitely going to appoint someone. Usually it'll be you, and it can be either the guardian or someone else in the family. If your child is not under guardianship, again, it's usually the parent. You would work with the Social Security Administration as to who that is. But you are now the representative payee, meaning you're going to go down to the bank. I went down to the local Citizens Bank and I opened up a bank account with Connor's Social Security number, but I'm the one who has access to the account. Connor does not. So it says Meredith Green as representative payee for Connor Green. It's his money, his SSI, but he can't deal with finances on his own. So I was appointed by the Social Security Administration, again, not by a judge or any court order, to be in charge of that money. So again, what this all comes down to is who is the decision maker and what are the choices they're making. So if the individual themselves is making their own decisions, that's what we call supported decision making. That is something that I'm going to talk about a little bit later on, but that's your child making their own decisions, maybe with some supports in place. If an agent is making those decisions, that's like a healthcare proxy. That's where you say, okay, if I'm unable to make my own decisions, I'm appointing my husband, my mother, my father, whoever, to make medical decisions for me. That's someone who's acting as my agent. These other ones, these are people who are making decisions for you. They're not your agent. They're making those decisions outside of you. So an attorney, in fact, in a durable power of attorney, the appointment of advocate, a trustee, as we talked about, that's the person in charge of the trust, the rep payee, which is Social Security, SSI, the guardian, the conservator, they're making decisions for somebody, but outside of their jurisdiction. The other person doesn't necessarily have a say. Whereas with the healthcare proxy, my agent only has the right to make decisions when I'm incapable of making them myself, when I'm either in a coma or I can't speak, things like that. All right, so we're going to get into the nitty-gritty of the guardianship. What is the basis for guardianship? Again, I already talked about least restrictive alternative, but you're not going to just go to court and say to the judge, my child can't make decisions, you need to appoint me as a guardian. The judge needs to find that your child has an inability to receive and evaluate information, to make and communicate decisions essential for their own physical health, safety, and self-care. This is bold. This is actually in the statute. This is what a judge needs to find. This is what a judge needs to declare as fact. Now, a judge is not going to just believe you standing up in court. A judge is not going to believe me if I'm representing you. A judge needs medical documentation from a professional that says that your child is incapable of processing information and making informed decisions. So where are you going to get that medical documentation? The good thing about guardianship is all of this documentation are court promulgated forms, meaning the court has created these shell documents that you or medical professionals or other people are going to fill in. You're not making anything up from scratch. You're not asking your child's doctor to just randomly create their own letter. There are court promulgated forms. So which form are you going to use? The medical certificate. A medical certificate is a document you use if your child is developmentally delayed, if they have a mental health issue, or again, your parent who has dementia. This is not for someone who is intellectually disabled. So the clinical team report, and I'm going to explain both of them and what the 30 days and 180 days means in a minute. The clinical team report is for someone who is intellectually disabled. Everybody else uses the medical certificate. So how do you know if your kid is intellectually disabled? Well, it's a medical diagnosis. It's a real term that is given by a professional, usually by a neuropsychologist. An intellectual disability basically means your child has a sub-average intelligence. The cutoff is usually somewhere in the early 70s. So your kid's IQ is 70, 71 or below. And they have adaptive functioning deficits, meaning communication, mobility, activities of daily living, all of those, there are deficits in those areas as well. So again, this is not something that you should be deciding whether or not your child is intellectually disabled. This is something that is a medical diagnosis by a neuropsychologist. Anyone who is not intellectually disabled, so that could be someone who is developmentally delayed but has a little bit higher IQ. Maybe their IQ is in the 80s or 80. Maybe someone who has autism, but again, has a higher level IQ. Someone who has mental health issues but has a normal IQ. Again, or your mom or dad who had a normal IQ their entire lives but now is suffering from Alzheimer's or dementia. Anybody who is not intellectually disabled uses the medical certificate. Now, these 30 days, 180 days, what that means is how long is this document good for? A medical certificate, 30 days. So someone who is developmentally delayed or has mental health issues, they may come in and out of competency. So when you first file your petition for guardianship, you need to file these medical documentations. So let's just say I'm filing the pleadings today, September 22nd. I need a medical certificate for someone who is not intellectually disabled. I need a medical certificate that is dated and based on an evaluation performed by a medical professional, by a doctor, within the last 30 days. So if the doctor signed the report yesterday, but he says, oh, I saw this person on July 28th, that medical certificate is stale. There are very, very specific guidelines, and the courts are not flexible about these. The evaluation has to be within 30 days of when you file that documentation with the court. You will need another one. If your child is not intellectually disabled, you will need another medical certificate at the time of hearing based on an evaluation done within 30 days of the hearing. So it'll be a second evaluation, again, by a medical professional, but you'll need another one. A lot of my clients...
Sorry,
Sure.
Meredith. We have a question in the chat. Just says, if my daughter is developmentally delayed and intellectually disabled, do I complete both forms? And I think you were just touching on that.
Yep, nope. If they are intellectually disabled, you use the clinical team report. It doesn't matter what other comorbidities there are. So someone could be intellectually disabled and have schizophrenia. That it doesn't matter. If they're intellectually disabled, you use that clinical team report.
Thank you.
So the clinical team report is a little more lenient in that the evaluations have to be performed within the last 180 days of when you file that form with the court. And when you file it is with your initial pleading. So when you're starting the process, you're sending in your initial pleadings to the court, you have to have that clinical team report with those. And that clinical team report is based on evaluations done within the last 180 days. So basically 6 months. So that gives you a little more leeway. The thing that's a little more difficult is it's not going to be signed by just one professional. It has to be 3 evaluations. You need a licensed psychologist, you need a licensed social worker, and you need any MD. So if your child sees a psychiatrist, the psychiatrist can do it. Otherwise, you can use your regular pediatrician, the developmental pediatrician, any MD. So a lot of times this corresponds well with your child's 3-year reevals at school. So as you know, your child has to get reevaluated, retested every 3 years at school. And if your child follows the typical timelines, usually that is done just before their 18th birthday's IEP. So the school psychologist is is a psychologist. They are an appropriate person to fill out this clinical team report. Most schools will have a social worker, although unfortunately not all. So you may have to run around to find that. But a lot of schools have that psychologist and social worker. So if you tell the school, hey, my child is turning 18. I know we're doing our 3-year reevals. I'm applying for guardianship, so I need the psychologist and social worker to evaluate my child within 180 days when I'm filing the pleadings and fill out this clinical team report. If you typically use a private neuropsych for your 3-year reevals, then you can still use that person. I get a lot of clients who will say, oh, I want to file for guardianship, say now on September 22nd, and I do a private neuropsych, and my kid was seen in January. That's 9 months. It's outside of the window. Do I have to do the entire new IQ testing and all the testing again and pay, if you're at a private neuropsych, $3,500, $4,000 for that? The answer is no. If you see a private neuropsych, even though the January date is 9 months and it's too late, you just ask your private neuropsych to make another appointment with your kid. It can be 15 minutes virtual on Zoom. And then they can say, okay, I saw this kid on September 22nd, and based on my seeing him now and reviewing the testing I did 9 months ago, and maybe even reviewing the testing from 3 years before that and 6 years before that, based on all of that prior knowledge and my seeing him today, September 22nd, I agree that this child needs guardianship. So it doesn't need to be that whole battery of testing again. It just needs to be enough that that psychologist, social worker, pediatrician, whoever it is comfortable enough saying, yes, I saw them today, and based on today and other information, I agree that the child needs guardianship.
Meredith, we have another question. It said, what if my son was evaluated last October and he turned 18 this past April? With COVID, we haven't been able to get this process. Is his 3-year still okay?
No, so the school whoever that psychologist is will need to see him again. Just like I said with the private neuropsych, they don't need to do the whole battery of testing again, but they need to see him so that they can say, I saw him now in September 2021, and based on that and my prior assessments, I agree he needs guardianship.
Okay,
So,
and sorry, some feedback, but she just added that he is ID, so that
yep.
I don't think that matters, but
yeah, if they were not intellectually disabled, you would not be using a psychologist. You would need an MD.
Right. Okay.
Yeah.
Thank you.
So it's only for those people with intellectual disability that you're using this clinical team report. But yes, all the evaluations need to be done within 180 days of when you file the pleadings. It's not within 180 days of the kid's 18th birthday. It's not 180 days of when the hearing is. It's 180 days from when you file the pleadings, starting that process with the court saying, I'm petitioning for guardianship. So when do you file? People ask that all the time. Courts will not accept a petition for guardianship more than 2 months before the kid's birthday. Typically, I like to do it around 6 weeks prior to the kid's birthday. That would be ideal. If you do it 9 weeks before the kid's birthday, most likely the court will send the documents back to you and say it's too early, we're not accepting them. So again, your child, for that one person, your child may already be 18. It doesn't matter. That's fine. You can still file it. But whenever you're aiming for filing it, so again, for the person who's already 18, when you file it is going to be based on when you can get that clinical team report done. But for people who are maybe 6 months out from the process, maybe your child is only 17 and a half right now, in terms of planning, you want those guardianship paperwork to be completed and ready to file 6 weeks before your kid's 18th birthday. So that will then give you that backtrack as to when does the 180 days start. So it's 180 days from when you file the pleadings, which hopefully will be 6 weeks before the kid's birthday. But it is what it is. So that's when you want to file. So the nature of this evaluation, what either the MD for the medical certificate or the psychologist, social worker, and MD for the clinical team report, just like all the other evaluations your kid has at school, it needs to be individualized and comprehensive. It needs to be based on your child, not your child's disability. So every once in a while, I'll get a clinical team report that says, why does this child need guardianship? And someone will write in there, Down syndrome. Well, just because the kid has Down syndrome doesn't mean they need guardianship. Tell me why this child, why does Connor Green need guardianship? What is it about Connor? You can say, well, his Williams syndrome has these symptoms, and this is specifically why Connor needs it. He has trouble with this, that, and the other thing. So it needs to be really individualized on your kid, not just a global assumption and recitation of what your child's diagnosis is. The clinical team report in the MedCert will ask about your child's strengths and their weaknesses. This sort of goes to tailoring the guardianship to the least restrictive alternative. If the medical certificate or the clinical team report says, oh, he's great at making decisions about his activities of daily living and this, that, and the other thing, and you are looking for full guardianship and you're not saying to the court, well, yeah, he can make his own decisions about activities of daily living, the judge is going to ask why, and that's going to be a red flag. So these evaluations are going to identify strengths as well as impairments and the need for guardianship. So once you are appointed guardian, what do you get to do? Well, as I said, it's guardian of the person. So you're making day-to-day decisions about that person, about their support, their care, their education, medical decisions, all of those things. I get a lot of people who will say to me, my child has autism and they're very aggressive and they can be physically aggressive both to themselves and to others. If I'm guardian, am I going to be liable if my kid hits someone out on the street? No, you have no personal liability for things that the person under guardianship, we call them the respondent, protected person, things that they do, you do not have personal liability over, so you shouldn't be worried about that. Also, you know, a lot of times we say to clients, think of it almost as an extension of your child being a minor, right? When your child is 17, you're making decisions for them. You are probably trying to instill as much independence as possible. You're probably letting them make as many independent decisions that they can safely make. But at the end of the day, you have veto power of a 17-year-old. They're a minor. You get to make the legal decision, even if you're letting them make decisions. That's your legal decision to let them make that decision. It's very similar to that, except in one big area, and I'm going to talk about that next. That's that substituted judgment, that Rogers guardianship. There are some decisions that the court says, a guardian can't make those decisions without running that by the judge. So I'm going to talk about that in a second. How long does the guardianship last? Well, forever. While the person is alive, the guardianship continues. Actually, I guess I should say while the guardian and the protected person are both alive. When the guardian, if the guardian passes, and we're talking parents, parent might die before the kid, well, the kid still needs guardianship, but somebody else is going to have to now apply for guardianship of that kid. And it's the same process. You're going to need to get a clinical team report again. You're going to have to file the petition again. So even though a kid has been under guardianship for 25 years and they're now, you know, in their 50s, you still have to do the same exhaustive process again. If the person, the respondent, the child dies, well, then the guardianship terminates. And it doesn't matter where the guardian is, other than they need to be in the U.S. But I have clients who will say, well, I want to be a snowbird. I want to get out of this weather. I want to go down and live in Florida for most of the year. But I'm my kid's guardian. What does that mean? You can still do that because you can still move to Florida. Or another scenario is when I pass, I'm planning on having, you know, my child's sibling, my other kid be guardian, but I don't want my other kid to feel like he has to live in Massachusetts. Well, that's not the case. The guardian can live outside of Massachusetts.
Great. So we have a couple questions.
Okay.
The first one is, once you have the CTR, what is the next step? How do you file? I assume you need an attorney, and does the attorney do the filing?
Yes. So I mean, I'm biased. I think you need an attorney just because there are a lot of deadlines and processes, and the court is not going to walk you through it. They're going to assume that either you figure it out yourself or you hire an attorney. That being said, a lot of times it's non-adversarial, meaning no one's going to object to it. So there are people who do it on their own. But an attorney would walk you through what documents they are. So you need a petition for guardianship. You need the medical certificate or CTR. You need a bond. You need a military affidavit. And then you'll get what happens after that. And I think this comes up later in the slide, but I might as well just say it now. What happens after that? You file those pleadings, and then the court takes those, they scan those documents in, and they docket it by giving it a number. And it will say which county, so it's the county that either you or your child is living in. So it'll give it a docket number, and then it'll issue what's called a citation, which is notice to the world that you are applying for guardianship. That notice starts this 28-day clock. By day 14, you are obligated to have provided that citation and a copy of the petition to all interested parties. Who are interested parties? Usually it means if your child is intellectually disabled, DDS. It means anyone and everyone who lives in that household. So even if you have a 2-year-old child, that 2-year-old child has to get notice in the mail. Your child has to be hand-delivered, this petition and the citation, by a disinterested person, meaning someone not related to them. Usually I have parents, you have the school do that. If you have, a best friend, neighbor, whoever that you want to do it, that's great too. It just can't be someone in your family, someone living with you. And that person has to then fill out part of the citation, indicating that they've done it by the deadline, by the time frame that you're supposed to. And that has to be then filled in with everyone that you've given notice via the mail to, and that goes to the court. After that 28-day period where anybody has the right to file objections, after that period, you can then ask for a hearing. I'll tell you, Worcester is pretty good about their hearing schedule. Worcester right now has, when you first file and you get that docket number, the file is automatically assigned to the next judge on the list. So in Worcester, every judge takes one Tuesday as their guardianship block day. And there are right now, they're in flux, but let's just say there's 7 probate guardianship judges. So each judge has one Tuesday in a 7-week period. So let's just say you have Judge German and his guardianship block day was yesterday. So you either had to have been on his list for September 21st, or the next hearing date is probably November 9th. I'm making that up, but whatever 7 weeks is. And there's a list. So you know exactly when your judge is scheduled for hearings and you get yourself on the list. Most other counties, if you live in other counties, are not as organized as all of that. Usually after the citation and you've returned it and they know that it's done correctly, everyone's received notice, Norfolk will assign you a hearing. Middlesex, you have to request the hearing date. So it all depends on the county. So you have to figure out what the procedures are in those counties. Middlesex right now is booking about 5 months after that 28-day hearing. Yeah, they're really, really backed up. Norfolk is a little bit better. They're a little bit closer. Again, Worcester, it could be that your judge is 3 weeks out on his hearing schedule. It could be that, again, he had his hearing yesterday and you're now looking at 7 more weeks. So that's sort of the procedure and the process.
So the next question was, how many co-guardians can be named?
So typically 2 is the max. I have done 3 when it's, it used to be mom and dad, or, it's mom now, but mom is, 78 or something, and we want to make sure that there's continuity. So then sometimes there are 2 siblings who are going to be co-guardians when mom can't. So sometimes I can get 3 appointed, mom and the 2 siblings, because mom is, as I said, in her 80s or something, for continuity. But if you're just starting out and you're looking at like 3 people that are in their 40s or 50s, a judge is going to probably question that. So you're really looking at 2 two would be good.
Okay. And then somebody did say that Norfolk is 2 months out right now. And then the last question we
Actually,
had.
I got one 3 weeks out right now for Norfolk, so it's very dependent, but yeah, Norfolk is much better than Middlesex.
If a guardianship has already been granted, can a guardian give a power of attorney to a spouse to help make decisions, or do you need to reapply to add the spouse as a co-guardian?
So it's not a power of attorney, but you can make someone, if you're the guardian, you can give someone authority, basically an agency document. It's only good for, can't remember off the top of my head if it's 60 days or 90 days, it needs to be notarized, but you can continuously do that and refresh that so that a spouse who is not guardian can make decisions. Yes.
Great. And one more. She said that we're hoping you have time to talk about supported decision-making tonight.
I'm going to get to that at the end.
And that you've been very helpful. Yes, so we're about 17 minutes out from 7 o'clock, but.
Oh, shoot.
Yeah.
All right.
We had some great questions though. All right.
All right. Well, I'm just going to keep going to get to the important stuff. So guardian can be anyone over the age of 18. If your child needs help with activities of daily living, you can be paid as a caregiver if your child is living with you. A parent can, but not if you're the guardian. So if you are a two-parent family, you can, in that situation, have one parent be the legal guardian, one parent be the AFC provider. I'm not going to get into that too much because we don't have a lot of time. Notice requirements, I'm going to go through all of this. This is the limitation. This is one thing that I wanted to stress, Rogers guardianship. So a guardian doesn't have the authority that a parent of a minor does. They can't do everything. You cannot admit someone to a mental health facility without a court order. You can't admit someone to a nursing home without a court order. You can't admit to extraordinary treatment without a court order. And what is that? This is the Rogers. If your child is taking an antipsychotic medication, it's a second layer of the guardianship, which means you need every year to get a court order allowing the specific treatment plan. So Connor used to take Risperdal. So I would need a court order saying it is okay to treat him with Risperdal. And if Risperdal doesn't work, then maybe we'll go to Abilify or something else. And it's all based on his treating physician's paperwork. So just understand that being a guardian is not the same as being the parent of a minor. Being a guardian, you're like a high-level manager. You get to make most day-to-day decisions, but there are some decisions that you got to run up to the CEO. And in this situation, the CEO is the judge and the court. So just be aware of that. All right, supported decision-making. Thank you for keeping me in line. Supported decision-making is basically the opposite of guardianship in that guardianship gives the guardian, parent, veto powers, right? You want to try to let the kid make their own decisions, but you have veto power and the kid can't do anything about it. Supported decision-making is the opposite. The kid has veto power. So this is where the child says, okay, I may need help with decisions and I need to have my parents, my siblings, maybe a really good friend, an aunt and uncle, whoever it is, help me make decisions. So supported decision-making is a concept that unfortunately right now in Massachusetts, we do not legislatively have supported decision-making. There are a number of states that have it, a small amount of states, but it's gaining traction. There are bills in front of the Massachusetts legislature every year in order to legislatively approve this as an actual thing. And that would be where the individual, so in my situation, Connor says, okay, I need help with my IEPs, I need help with my medical decisions, maybe I need help with finances, but I can do my own, like decide who I'm going to be friends with and sort of community decisions. I can do that myself. So he's going to decide where he needs help and he's going to decide who is going to help him. And he's going to, it can even be a team of supporters. So again, you can look at this. I know you guys have this. You can look at this. This is just all about supported decision-making. I'm sort of going to go through it quickly quickly because we don't have it in Massachusetts yet. So what we have is what we call our supported decision-making, our alternatives. This is what's available right now. A power of attorney, a healthcare proxy. I have my own appointment of advocate form and a HIPAA release. So these are sort of our form of supported decision-making that we have here in Massachusetts. So what are these documents? A durable power of attorney or an appointment of advocate. It's basically the same power of attorney that you should have as part of your estate plan, whereby Connor says, okay, if I can't make financial decisions on my own, I want mom and dad to be able to help me. I want mom and dad to be able to go into a bank teller if Connor has his own bank account. Now, again, this is not the rep payee account because if I'm his rep payee, I already have control over that. But Connor has his own checking account. I want mom and dad to be able to go in there and make decisions for me. I want the teller to be able to talk to mom and dad. I want mom and dad to be able to transfer money, to be able to shut down an account that isn't working, open a new one, do whatever it is financially that Connor has the right to do. He's giving me the right to do as well. That's the power of attorney. It deals with assets and property. Now, again, he has veto power. So if I say, okay, I'm going to go to the bank and I'm going to, put a stop on a check you wrote, if he says, no, you're not, and he calls the bank and says, no, well, he has veto power. It's his decision, right? He's not under guardianship. He has the right to make his own decisions. The appointment of advocate is a document that we have created that talks about, well, who's going to sign my IEPs? If the child is now out of the school system, they're over 22, who's going to sign the ISP? That's what it's called when you're an adult. Basically the same type of thing, except instead of an education plan, it's a service plan. Who's going to help me talk to DDS or Department of Mental Health or MRC, whoever the adult agency is that is providing services for your child when they're an adult? Who gets to help them and who gets notice of any meetings or any change to any services? This is your child. This is, again, my hypothetical. Connor saying, okay, I want mom and dad to get all the notices I get. But again, he has veto power. So if we're in an IEP or an ISP meeting and we all agree, oh yeah, he needs this, and Connor says, no, I'm not doing it. I don't want that service. I don't want that pullout. Or I don't want mom and dad at the IEP or the ISP meeting anymore. Well, he's an adult. He gets to make his own decisions and you don't get to come. Again, if you're thinking of these alternatives, these are great documents if your child is somewhat compliant, if your child relies on you and seeks your opinion and your assistance. This doesn't mean that in order to have these documents, your child has to be able to make every decision they're ever going to make independently, or my child has to be able to perform all of his ADLs on his own, or my child has to be able to live totally independently in order to do these documents. That's not what this is. If you think about it, right, like I know nothing about cars. So if I need a new car, I'm legally an adult. I can go to whatever car place I want, whatever dealership I want. I can buy whatever I want. But I'm going to probably reach out to my brother's father-in-law, who's a mechanic, and say, hey, can you give me some ideas? This is what I need in a car. These are my parameters. These are what I'm thinking. What should I be looking at? And he's going to let me know what I should be looking at. And realistically, I'm just going to rely on him because I have no idea. When I'm buying a new house, right, I'm going to have my mother come walk through and give me her opinion. I'm going to have my best friend look online and tell me what she thinks. If I'm picking paint colors for rooms, good God, you don't want me picking paint colors for rooms. I'm going to either hire someone to do it or I'm going to ask people's opinions, right? Just because I am not doing it independently myself doesn't mean I don't have the right to make that decision. So think of that for your child as well. Just because they can't live independently, just because they can't make their own medical decisions completely independently, if they have competency to make decisions and they know to rely on you, then maybe these documents are a great thing. It keeps you out of the court system, but you have to know that your child has veto power. So as long as they're looking to you, it's just like me asking someone for a paint color. They could say, oh, you should have this color. But if I say, oh, I really want screaming red, well, I can paint it screaming red if I want. So that's sort of the basic difference between the two. Who has veto power, you or your child? And again, if your child has veto power, it doesn't mean they have to make every decision independently. They can loop people in, they can ask for advice, they can even say, I don't know, Mom, you decide. But they have to have the competency to at least know that they're making decisions, even if it's with help. So again, the healthcare proxy is similar. It's who's going to make medical decisions. The healthcare proxy is the only document in these alternatives that stipulates that someone is making those decisions if and when the person can't make them themselves. In actuality, the way this usually works for kids with disabilities and special needs means if I have a healthcare proxy, Connor is signed a healthcare proxy saying Mom and Dad gets to make decisions for me, even though we're both walking into his developmental pediatrician's office and he's awake, he's not in a coma, he can communicate, he's verbal. Technically, if that was my healthcare proxy appointing my husband's not making decisions for me because I'm walking, I'm talking, I'm able to make my own decisions. But in this situation, the reality of the situation, the practicality of it is most doctors are going to say, okay, Connor, this is what we want to do for your meds. What do you think? And if he looks at me and says, Mom, the doctor's going to then talk to me. That's enough of Connor saying, okay, I want Mom and Dad to be able to make that decision. It also gives you access to the doctor, right? You can call and the doctor will talk to you if he has a healthcare proxy on file. Again, if you don't have a healthcare proxy on file and you're calling for your 19-year-old son, in a lot of cases, if it's a doctor you've seen all the time, a lot of times they will talk to you. Legally, they should not. Legally, it's just like my husband calling my doctor up and saying, hey, I want to talk to you about what medication she's on. Legally, my doctor's not allowed to talk to my husband or my sister or my kids about that. But in practicality, a lot of doctors sort of go along to get along and they understand the reality of the situation. So I'm not going to go through all of that. So I know I am at the end. I only have 5 more minutes. Any other questions? I know I flew through that and I apologize.
So there's nothing else in the chat right now.
Okay.
So if anybody wants to unmute and ask a question.
Where do you fill out the power of attorney?
So again, those are legal documents. So just like your own power of attorney, I would imagine you probably went to an attorney for that. So you can go to an attorney. I mean, I know there are like legal Zooms and things online. Again, I'm biased. I wouldn't trust those, but yeah, those are legal documents.
Okay, thank you.
You're welcome.
Question about the CTR.
There was a question that said the last few documents, would they be okay to go through legal Zoom?
Yeah, I mean, I wouldn't. You know, I think that's sort of like Googling WebMD when you have a problem and you're looking for a diagnosis. People do it, but if you want it done correctly, I would not. Carrie's laughing at.
They want to know if you have an office outside of Boston. Are you just based in Boston?
Right now we're based in Boston, but we're doing most of our intakes and even signings over Zoom. So most of my clients don't ever actually have to come to Boston.
And you touched on all the slides, correct? Somebody just said, what didn't you have time to go over? But I think you just went through things fast.
I just went through things fast. Typically, I do a deeper dive on the Rogers guardianship and the things that even when you're appointed guardian, you can't do. Just I find a lot of clients are sort of surprised when they want to do something and a doctor or someone says, oh, you need a specific court order for that. So usually I go into that a little bit more deeply. But again, if your child is on an antipsychotic medication, that is one that you'll need a judge's approval on every year. That's called a Rogers guardianship. But there are other things that are written in statute. So abortions or vasectomies, things like that, you cannot do that without a court order. Electroshock therapy, you cannot do that without a court order. Basically, it's the state saying, okay, this person is incapable of making their own decisions. We're going to appoint a guardian who can do day-to-day decisions for them, but something that is significant, like an abortion or a sterilization, end of life care, right? Taking someone off child support, electroshock therapy, antipsychotic medications, the side effects can be so significant that the state has said, okay, we need the guardian to come back to the judge and basically make their case. Give me an affidavit from the doctor saying, these are the risks, these are the rewards, this is why we're doing it, this is why it makes sense, and a judge is going to make those decisions. A guardian doesn't have the capacity to make those decisions because a lot of times we don't have a loving family member to be guardian. There are a lot of people out there that have a professional, and we don't want, some professional who may only see that person 2 or 3 times a year making end-of-life decisions willy-nilly. So it's a hassle for loving parents, unfortunately, but I think the overall good is
I
served.
think Kathy Gurdon had a question.
Sure. Hi, Kathy.
Oh, hi. Nicholas has asked for help with 3 things, and he asked me to ask these. He's autistic. He's 18. He's high functioning. He said, all I want to know is like, for example, he's going to the neurologist tomorrow, and he said, can you come in? I'm nervous because I don't remember everything to ask him. So that's one. He said, and then at college, he said, they won't talk to me, but he wants me to help ask questions, but they'll only talk to Nicholas. And because of his autism, he said, they don't understand some of the questions I have. He says, can I get anything signed that they'll talk to you? And banking. He says, just 3 things I need help with: doctor's appointments, college, and banking. He said, that's what he says, I just need, he goes, Kathy, I just need help with those.
Yeah. So the first one, doctor's appointments, if you go with him, he has the right to say whether he wants you in the room or not. I mean, a lot of time doctors, they do have this whole, we want to make sure that no one's abusing you and all that. So they may want to talk to him by himself and do some of it by himself. But if he says, I want my mom in the room when we sort of talk about what my issues are or why I'm here and or what the steps are afterward, just like if I had complex medical diagnosis, right? Like a lot of times if someone has a cancer diagnosis, they say, okay, can you bring your husband or a support person with you so that more than one person is listening? So as long as he says, I want mom in the room with me, I want Kathy in the room with me, you can be there. Again, the neurologist is probably going to want to have some one-on-one time, but especially if he says, I don't understand everything, I need her there, they'll allow that.
Okay.
School is a little different. There isn't, all of these documents. Schools sometimes recognize them, sometimes don't. So the easiest thing there is when he is speaking to someone that he thinks he's going to need help with, either do a conference call, and I'm going to have Kathy on the call with me, or, if he's meeting with them in person, maybe you can be on the phone with him, but he has to make that advocacy step to say, I want Kathy on the phone with me.
Okay.
Right? They're not going to talk to you without him in that situation, unless he's in a specific, some colleges in their disability programs, sometimes they will be a little more lenient, but a lot of times they're saying, hey, you know what, like you're in college, do it yourself. And if you want someone there, you have to at least advocate and say, okay, I'm going to make the call and have Kathy on the phone, all of that. But they're not going to let you just call the dean or someone and talk on his behalf.
Gotcha.
Last one with banking, again, a power of attorney should take care of that. Otherwise, you'll have to be there with him in order for you to talk to a bank or make any financial decisions. So you either have to be there side by side or get a power of attorney.
Okay, thank you very much. Thank you.
And Michelle had a question. So Michelle, you want to ask yours?
Can you hear me?
Yeah, I can hear you. So several times over the last, 4 years, I had Abby fill out a healthcare proxy, and I was the healthcare proxy person. and she has disabilities, and she actually had to end up going to the hospital, and they ended up taking her into the psych ward, and I could not go with her, even though I had a healthcare proxy. And like, they were asking her all kinds of questions, and they were, she didn't know the answers to. So like, the clinician had to keep coming out to me. And then she goes, well, we can't find the healthcare proxy. Like, I must have filled one out like 7 times. Every time we go to the hospital, I'd fill one out. And they've never, ever asked for the copy of it. They're supposed to have it on file at the hospital. It's so, how does that help in any way? She was literally terrified when they took her back there because she didn't know anything. And of course, people were talking to her, and there was something on TV that was completely inappropriate for like, so the healthcare
Is that
proxy didn't
something that she
protect
should
her.
carry with her, Meredith?
Yeah, I
like-
mean, how does that work? I had it
Yes.
with me. I had a copy in my hand. And she goes, okay, yeah, that doesn't work for this. I
Yeah,
don't
well,
understand.
if it's a healthcare proxy for a specific hospital, it's not going to be used elsewhere. You need a general healthcare proxy, not one specifically. I mean, every time you go in for a procedure, right? When I have my kids, they make me sign one, but it's only specific to that procedure in that hospital. So you need a general one. But the other thing is, again, just like if I was in a psych ward, if I don't say I want if I'm coherent and I'm able to make my own decisions, a healthcare proxy doesn't trump me. I have to say I want my husband to make decisions, or I have to be completely incapable of communicating my own decisions for the healthcare to work. So the healthcare proxy, A, could have been specific to a hospital that you weren't at, and therefore it didn't work. But
No.
B, yes, they're going to need it constantly. They're going to lose it all the time. Same thing with guardianship. They will lose your guardianship decree all the time. You need to have copies with you all the time, whether it's just on your phone, in email, or whatever. But if your daughter says, I want my mom to help me, she's my healthcare proxy, they should let you. That's the law.
No, they told her I couldn't. They said that due to the, it would interfere with the other people's privacy, is what they said. That's why I couldn't help. That's why I couldn't go back there, because it would interfere with the other people's privacy.
Yeah, and that might be the case even with guardianship, and they would come out and talk to you. But, the hospital's regulations are their regulations, and you're not going to be able to trump that. If that's their regulation, that's their regulation.
And
Same
then,
thing with COVID. Even people under guardianship, if someone was in the hospital in the last, 18 months, guardian is not going in. Doesn't matter. Hospital regulations trump.
So we have one last question. It was actually a different Michelle that wanted to ask, but she had to jump off. So she said she'd try and figure it out. I'll have her email me the question and maybe we can get it figured out. But the last question we had was, if we got temporary guardianship when our child turned 18, should permanent guardianship be straightforward? They have a court date next week.
It should be, yeah. So usually, yeah, so it should be, as long as you have all the paperwork in place, as long as your child isn't objecting and no one else is objecting, then yes, it should be pretty straightforward. I mean, it depends on the circumstances as to why you had the temp and all that, but
Yep.
typically, yes.
Right.
Thank you so much for your time, Meredith. We really appreciate it. As you can see, this was a great topic for everybody. So I appreciate your time. And if we get any further questions coming in, I'll see if I can pass them along to you. But otherwise, we have your slides I shared with everybody. And if anybody has any questions going forward, if you want to give me an email. Oh, Carrie, are you raising your hand? No? Okay.
No, I wasn't, but thank you, Meredith. Nice to see you.
Welcome.
Thank you.
Thank you
Meredith,
all
you-
so
you
much. Have a
share your
great
information.
evening.
Hey, thank you so
Thank
much.
you.
Bye-bye.
Thank you.